the stabbing deaths of victims Madison Mogen, Kaylee Consalves, Xana Kernodle, and Ethan Chapin. These 4 University of Idaho students fatally stabbed to death in the early morning hours, November 13th, 2022. If he is convicted, prosecutors are seeking the death penalty. Now, yesterday, the defense motioned to compel after the state did not turn over a lot of discovery. Happens all the time. The state argues that there is too much information that may be released to the public. So let's hear what the prosecution said. This is Ashley Jennings. This is her argument.
Both contemplate balancing this public right to an open hearing versus the interests such as privacy, safety, and the right to a public trial or to a fair trial. In deciding whether or not to file the motion to close the hearing, the state weighed those interests and ultimately came down that the need to protect the privacy and the sensitive information and ultimately protect the state and defendant's right to a fair trial outweighs the right to an open hearing. If the court decides to open this hearing to the public, the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions, and false narratives. The evidence discussed may not even be offered, and most of it likely will not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate that. It is necessary to mitigate this by closing the hearing in order to preserve the right to a fair trial for both parties. The defendant does have a right to a public trial, but that does not mean the right to try this case in media. The defendant will get his day in court, and the public will have a right to see what evidence the state has. But that should be evidence that is admissible pursuant to the Idaho Rules of Evidence.
So the prosecution saying, nope, let's shut it down. Let's hear what Kohberger's defense attorney, Ann Taylor, has to say.
If you look at them, they are to talk about openness of the court and public's right to have information and what things the court can shield from the public and what the public has a right to know. And when we're talking about documents, it's been brought up that we've filed a lot of documents under seal. We have. Those are documents that end up in the public record that thousands of people can read. And we filed those under seal for expediency and saying this is exactly what we want from discovery. But what we're talking about now is a public hearing when the state has decided to not give us information or to drag their feet on giving us information. We're talking about a public hearing where we have a right to be in the public eye, a public hearing. Bryan's the one with the right. It's his Sixth Amendment right to have a public hearing. For the court to allow the prosecutor to say, we need to keep this all private for a fair trial really ignores the public nature of this case. It really ignores the fact that Bryan has been essentially convicted in the media. You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public so that people can see it's not this neat little package. So people can start to wonder if Bryan's innocent. Your Honor, Bryan is innocent. And he has an absolute Sixth Amendment right to have his hearings in public.
All righty, so the battle lines have been drawn. Still with me is trial attorney Katherine Lizardo. And joining us in the firm this hour is Sky Lizardo. Thank you so much for being here, Sky. I appreciate it. So let me ask you, Katherine, it's a good battle. We always see these. What's too much? What is the prosecution playing hide the ball about? Where are you on this thing?
Well, I always believe to give everything that you have as long as they're not privileged. And so whether you believe it's relevant or not, it's not really for you to decide. Give it and let them decide, because if you don't give the evidence out there, then they'll assume you're hiding something, which creates all of this drawback and this delay and these motions. And so as a lawyer for over 20 years, I just believe you streamline and give the other side everything. That ensures a fair trial and finding exactly who the killers are for these murders. And this hearing, though, as to whether or not this hearing should be public, that's a whole different issue, because the defense is arguing that there should be a public hearing because he has a right to a fair trial for a public hearing. He doesn't have a constitutional right for a public hearing shown on the media. He has a right to a fair trial.
Yeah, that's kind of a secondary analysis. And we haven't even gotten there yet because they haven't seen the materials. So, Sky, it starts to look like prosecution is, keeping things a little undercover here and not willing to share them. Why? What are they hiding? And why worry about, are they really worried about tainting the jury pool with things that do get out there? I think that's just a little premature. What do you think?
I don't think they get to make that determination. I mean, they're the state under Brady v. Maryland and all the other case law that follows. The state doesn't get to make that analysis by themselves. They have to turn everything over. Now, whether it's relevant or admissible or needs to be, provided under a protective order is a different analysis, but they don't get to withhold information, period. Like, you're the state, you don't get to do that. That can result in a dismissal.
Yep. Well, the prosecutor, she went on to say that there may be a day for all of this, and that might be trial, but however, no right to try the case in the media. That's their concern. Well, let's see what Judge had to say after this hearing.
All right. Well, I kind of mentioned this a moment ago. I just feel like we need to get into the details, okay, of all these issues before I open it up. So I'm going to close that hearing. Now, that doesn't mean that after we sort out all of those issues and I have more understanding of why you aren't getting what you want or what you asked for, or whether or not there is something that you've asked for that doesn't exist, or that some of the materials are holding with the FBI, and that we need to get that. I mean, those are all really complicated processes. And I would feel much more comfortable when, again, I'm trying to protect a fair public trial and not have a maybe not intentional, unfair hearing, okay, that goes out to the public. I think that's the balance for me. That I want to see what all the issues are, the arguments from both sides, so that I can make more informed decisions.
All right, here, let me distill that for you, because judges tend to give you lots of sides because they're protecting the record. But the judge did end up agreeing with the state, at least at this point, to close the hearing. Okay, so it's confirmed too. This is important. We knew there'd be a change of venue motion coming. There has been one on the books. It's going to be on June 27th. They've moved that from May 14th. So this case continues to live and breathe. As I've said before, a trial is a living, breathing thing. We haven't even got to that part of the animal yet. Katherine is here. Sky is here. Sky, the parents of these 4 victims have constantly bemoaned how slowly this thing is proceeding. This happening doesn't really speed things up much.
It does not. And I think everybody involved in the court process, victims, families, and defendants alike, are always frustrated by how slow it goes and how you have to take everything one piece at a time. And I saw their statement about, we're gonna have a hearing after this hearing to talk about this hearing. And I get it. It's probably not as efficient as it could be, but unfortunately that's the process we have to make sure decisions are made correctly.
Yeah. Katherine, the change of venue, which is hanging over us, everybody wants to go to Boise, bigger jury pool. I don't know. This is one of my Mars cases. Unless you live on Mars, you know about this case, you know the details. Do you grant the change of venue or not?
Right now, if I was a judge, no, I would not. Like you said, everyone knows about this case unless you're living under a rock somewhere. So whether it's a bigger jury pool or not, they know and they've heard it. And that's why the defense is trying to say, hey, let's open this to the public, whatever hearing we have, because the reality is that the jury pool is getting tainted wherever that would be. So the venue motion and hearing is very critical for the defense here because they want a fair trial, but wherever he would be, yes, there has been negative publicity for him, rightfully so, right now, even though he's presumed innocent.
Hey, let me flash back on it, and you're right. You go from Moscow, Idaho to Boise, still pretty small. But Boise is markedly larger, and I can't imagine you walk up to anybody on the street and they haven't heard about the case. Sky, they destroyed the house where this all took place, and that was a big problem for a lot of folks watching this case unfold. What's your thought on that?
On destroying the house, I think that's hard. I think it probably has evidentiary value. I don't know what the defense's position was on that, but there's reasons to revisit crime scenes for investigatory purposes. I've had cases where judges have allowed juries to visit crime scenes. Now, obviously, you object to it most of the time, but having it be gone is almost a destruction of evidence in some ways, I think, in this case.
Yeah, that was certainly the complaint being made. What, you don't like jury visits? What's wrong? I mean, don't you think you can spin a jury visit either way?
I think you can. And I think, depending on the case, they're very helpful. I think I always go visit crime scenes for that very reason. It's hard to talk and visualize what happened in a place if you haven't been there. And from a defense standpoint, it allows you to make arguments about how it wasn't possible, or, how someone would have heard it, or it couldn't have been him, or whatever it is. But the reality is, without it, you have nothing.
Interesting. Well, speaking of jury visits, we are going to, of course, keep track of this case as it unfolds here in Idaho. But the Karen Reed jury is on a jury visit right now, one of the cases we are covering. So stay where you are. We'll bring you up to speed on the Karen Reed case, obviously Kohberger, Daybell, and much more. Stay where you are. This is Law and Crime.